Hello?
Hello, Mr. Hussain. It's Sian calling from the Legal Ombudsman.
Oh, yeah. Hello, Sian. How are you?
Hello, good, thank you. Are you?
Yes, I'm okay.
Oh, good. Can I just run through the security questions with you? Is that okay?
Yeah, sure.
Thank you. Just confirm your full name,
Mr. Sajid Hussain.
your email address.
Fatahbegum@gmail.com.
Thank you. The solicitors that the complaint's about.
Burke Niazi Solicitors.
Thank you so much. Yeah, brilliant. Thank you for giving me some further time with you, Mr. Hussain. So today is really just about confirming your complaints, trying to get them confirmed today, and then we'll get the case progressed. I do have another call at 3 o'clock, but I don't think we'll take longer than that because we've spent some time discussing the issues that you've got, haven't we?
Yeah, that's right. Yes, hopefully we'll be done before 3. I mean, all it was just basically getting something written down at this stage.
Yeah.
So we've got like some sort of terms of reference and stuff. And so I think when we were speaking last, I was trying to explain the situation that happened around about July or August time last year, or September, and so I mean, obviously, I've gone away and thought about some of the issues that have happened, and the reality is that one of the problems, like for example, if I take a point in time, let's just say at the end of July, there were like I believe 6 or 7 different issues, separate issues that were live, and at that stage, the solicitor, was telling me that he, there's nothing further to speak about, and I was trying to. So that's a point of complaint, is that, like for example, towards the end of July, just to go through what those points were, I had originally approached the solicitor with two basic objectives. First of all, was to appeal the decision of the final hearing, which I had not attended. And at that stage, so that was one issue, and the second issue was trying to find ways to get to see my mother, and for other family members to get to see my mother. So those were two issues that I had brought to the attention of the judge, sorry, the solicitor. But in
Yeah.
but in parallel, obviously that was my objectives. There were other objectives by the local authority, because the case was still ongoing, and one of those was basically the review of the injunction orders that have been put in place, and also a review of the care package presently in place, being put in place in my absence. So that's up to 4 points there. And then obviously towards the end of, after speaking to Mr. Barrett, they had raised a new issue, which was regarding my mental capacity to give them instructions. And also, when I had originally approached Mr. Barrett of Burke Niazi, there was another issue regarding committal proceedings. And then early on in April, when we had a telephone conversation, obviously I made Burke Niazi aware that there were also committal proceedings. And as I explained, he was quite keen then, because there were obviously there was like easy funding available for that, but then he learned that there were no committal proceedings. The local authority had withdrawn those original committal proceedings. However, due to the delay in the solicitor taking, being secured by me, namely the legal aid issue, by the middle of April, there was a requirement for me to respond. When I had done so, that had triggered off an injunction violation. So there were further committal proceedings. So there was like six, 7 different on concurrent issues. Oh yeah, so that was number 5, and then number 6 was that there was another in the background. There was a CCG application with the local authority in vaccination. So I've just reviewed some of the issues, and I think the pivotal points are the court dates. Because originally, when I approached Mr. Barrett, there was a court date listed for the 20th of May, and that's what Mr. Barrett was aware of. And then subsequently, because of his delay in order to represent me, there was a further court date on the 12th of May, which he was not able to represent me on because he had still failed to get the legal aid in place. And it's at that hearing that I have a further complaint and that complaint consists of that. As I explained previously, that I had once I learned that Mr. Barrett had been in communication with the local authority. I instructed him in writing not to communicate with the other parties without my express permission. However, on the 12th of May, when there was a hearing, the official solicitor had contacted Mr. Barrett, and Mr. Barrett had spoken to the official solicitor, because one of the issues I have a grievance of is that on the hearing on the 12th of May, nobody knew about my legal representation, and that was a committal proceeding. And at the hearing, I informed the courts. No, I was not even given an opportunity to inform the courts that I have sought legal representation and seek an adjournment. To my surprise, the official solicitor had told me that they had been made aware that Burke Niazi was representing me, and they had spoken to Burke Niazi. So that obviously was an area of concern to me, because I was robbed of the opportunity to inform other parties. And what concerned me is that how would the official solicitor know information regarding my legal representation when I had not informed them? And then when I questioned Mr. Barrett about this, and then he had told me that he did not contact the official solicitors. The official solicitors had contacted him regarding the status of his involvement as my representative. But then I asked him, well, how did they know? And then he was saying, I don't know. But the reality is that they must have been then informed by the local authority. But then the local authority were only made aware that Burke Niazi's involvement because of his discussions earlier on. So can you understand that the focus of my complaint here is that on the 12th of May, while I was at a court hearing, Mr. Barrett had spoken to the official solicitor, against my instructions, but his defense was that he had not contacted them, that they had contacted him. But irrespective of who contacted who, clear instructions were given not to communicate with anybody. And obviously it's like very convoluted now, because the bottom line is, the outcome is that at the hearing on the 12th, I was looking to make the parties aware that I was seeking legal representation, and legal aid was available. However, that opportunity was robbed of me because of
he'd already told them he was acting for you.
Yeah, well, no, he had already told not the official solicitor, who was a party. And so and then when I asked Mrs. Barrett about it, he said, well, what's the problem with that? Well, the problem is that if I'm in court and I'm not represented because of his failure to seek legal aid, so I'm there, so I should be in the, basically it's about, ex-party communications taking place without my authority or permission, which is not really to my detriment, but it was an issue of concern to me that this communication was happening, so I made it quite clear to him. But that hearing got adjourned, because the judge agreed that obviously I should be legally represented, and especially if there's a legal aid solicitor available. So then the next hearing was on, I believe, on the 20th or the 21st, which was to discuss the review of the injunction orders. So this was not to do with just to review everything. But then the next concern I have is that, or issue of complaint I have, is that the barrister, I had only got to speak to the barrister just an hour before the hearing, and it was very rushed. So I was literally given very limited time to speak to the barrister for this hearing, and this could have been arranged a lot sooner. So the first time I got to speak to the barrister was, I think, on the 20th of May, maybe an hour or two before the hearing, for a quick discussion. And so that's an issue of complaint to me, because that could have been arranged a lot sooner, because there was quite a lot of things going on, as you can appreciate, that there were at this stage four or five different live issues, because there was new committal proceedings that had commenced. There were I still wanted to review the injunction order. I wanted to see my mother. I wanted to know what kind of care package was in place. So my further complaint is that not adequate. First of all, the barrister was already selected by Mr. Barra in our telephone conversation on the 9th of April. So he already made that selection and advised me to, that this is the best option. So I took up that advice. But then from that conversation on the 9th, telephone conversation on the 9th of April, up until the 20th of May, I didn't even get to speak to the barrister, at length, to be fully advised of what's going to happen at this hearing on the 20th. So that's a second, further aspect of complaint of. Sorry.
Yeah. So so you want it separated to two complaints. So the first complaint is that the firm didn't really consult you before instructing a barrister. Is that your first complaint? They chose the barrister. They didn't ask, or they didn't really consult you in regards to assigning a barrister. Is that correct?
Well, no. He had basically said, look, I've already got somebody in mind that, and they're the most suitable person to carry this out. And then when I told him that there were further committal proceedings, then he said, oh, I'm even more encouraged. So basically, he said, I'll send you a profile, you can just review it. So basically, my first complaint is that this was, he's already advising me of which barrister to take on board. All right. So if he's basically, my first aspect of the complaint is that he's already advising me his preference without providing me with an alternative.
Okay.
All right, and it seemed quite keen that he wanted to work with a barrister, and he felt that was in my best interest. So that's the first aspect of the complaint. And now that I can you appreciate one barrister? I don't know the barrister's professions. I don't have a preference, but there were no alternatives provided to me. It was basically, here's a barrister. I think he's the best, and I'm going to send you his profile. And I think you should basically. I was corralled into selecting this barrister, which was obviously somebody who the solicitor wanted to work with, because he had worked with them beforehand. So then.
Okay, so yes, the first complaint being then that you think that the firm should have given you more choice in terms of barrister, but basically they just give you, here's one barrister, we think you should use him.
That's it, yes.
Yes, okay. And then obviously your second complaint is that they come in on the 9th of April and you don't get to speak to them until the 20th of May, which is an hour or two before the actual hearing.
Yes, but basically, they've not come on. Remember, in April, they're not formally secured by me. However, he's made a recommendation. Subsequently, following that call on the 9th of April, he's forwarded to me, the barrister's profile, and I said, okay, yes, let's just get on. My eagerness was to just get on with things. All right. And so my second aspect of the complaint is that from the 9th of April, when he had already selected a barrister and I had agreed to it, then there's been no communication between me and the barrister until I think an hour before the hearing on the 20th of May. Yeah. Okay.
I'm with you, so we can absolutely take them forward.
Yeah. And so then, in addition to that, obviously everything was quite rushed. So there's quite a number of things that need to happen at the hearing, and I can't speak. And the barrister who's only just got involved, doesn't know the full breadth of the complexity of everything. And then subsequently, my further aspect of this complaint is that after the hearing, I thought, all right, well, fair enough. We haven't had much time to speak to the barrister beforehand. So hopefully I'll get to speak to the barrister after the hearing. So my further complaint is that after the hearing, the solicitor and barrister were not available. Ideally they should have, I should have spoken to the barrister before the hearing, yes, so I'm fully well represented, and then subsequently after the hearing, everything should have been a further conference call should have taken place, so that I could have, everything was fresh in my mind, I could have asked questions, seek clarity of what's happening. That conference call did not take place until the following week. So that's a further aspect of complaint, is that on the one hand you've selected the barrister, and I've agreed to it, and then not given me much choice, and then with regards to the barrister, I've only got to speak to them an hour before, and that could have been arranged a lot sooner, but that was because of their delay to secure legal aid funding. And then after the hearing, I wanted to speak, because obviously I had loads of questions to ask, and that was delayed for a further week. So that's a further aspect of a complaint.
Yeah, I'm with you. Did you have any? Did you try to get in touch with them to discuss it, but they just didn't come back to you until a week after the trial?
Well, sorry,
hearing.
the hearing, yes, and the I had it asked straight afterwards. I want to speak to the barrister, and they thought, oh, she's not available right now, and then it got delayed for until the following week.
Okay. Yeah, no, that's so we can include that. That's absolutely fine. Yeah.
Yeah. So that was all around in May time, and obviously at the hearing in May, there were orders given, as I explained last time, that I think around about the 14th or 15th of June, I had to submit a statement to the courts. So that was an order that was. So there was a hearing in May. The hearing on the 12th of May was not very substantial. Basically, it was a committal proceedings that could not proceed because the judge recognized that there was I was going to get legally represented, and he agreed that it should be. And then on the substantive hearing on the 20th of May was basically rushed through. Then there's quite a lot of things that were happening, and one of the orders had stated, the clear order had stated that, I think I'm just guessing a date here, in June, I think 14th of June. It was a Friday that I had to submit. I think mid-June or Friday, I had to submit a statement with by the 14th. Let's just say Friday the 14th. I'm not sure if that date's correct, but Friday the 14th of June, and. So I knew. So both myself, the barrister, and the solicitor knew that a statement was ordered to be submitted, and I think it was something along the lines of what I feel about the committal proceedings or what injunctions I want to get changed. I can't remember the exact details of it, but I know that there was I was ordered to submit a statement by the mid June, and whereas in April I was required to submit a statement and I was not legally represented, this time I was confident that at this time that the statement, any court orders would be dealt with, because now I was legally represented. I had a barrister, and there was not an issue. So I had an initial consultation with the barrister following the hearing on the 20th, and obviously at that stage, this was the first opportunity that I got to seek legal advice from the barrister regarding, first of all, appealing the final hearing, appealing the trial of the final hearing in February, and also I had asked for advice regarding my ability to appeal the decisions and the injunction orders, because that was the whole purpose of me contacting the solicitors. I also talked about seeking legal advice, because I had made it quite clear that my understanding was that the judge in this case, Mr. Justice Cohen's services, had been privately commissioned out by the local authority. So I was making some serious allegations regarding judicial fraud and corruption, and so that was the first opportunity that I had to speak to the barrister. And then subsequently, I believe there was a follow-up. There was a follow-up consultation between me and the barrister. I'm not sure if there was a follow-up consultation, but as I explained, I was trying to speak to Mr. Barrett, because the barrister's services are very limited. Obviously, the main points I need to raise to the solicitor. So I was constantly, after May, early June, I was constantly trying to speak to the barrister, the solicitor, trying to gain clarity of understanding of what's happened at this hearing, what's happened at the previous hearing, some advice. But then there was the further aspect of complaint I have is that the solicitor and the barrister had got together and had consultations in my absence, and concluded that the barrister felt that I lacked litigation capacity. All right, and they had not made me aware of this. That's what they had concluded. So if there was a consultation that has taken place before, at the early stages of June, they had a consultation, and they had agreed between themselves that the way that they're going to be proceeding forward is to say that I lack litigation capacity. However, they had not made me aware of this. That's what they had concluded. So that's a further aspect of a complaint, that if there was any communication or any consultation taking place between my solicitor and my barrister, who are two independent parties, then I should be involved in that. So can you understand? Formally, he's my solicitor that I'm giving instructions to, and the barrister is an independent party that purportedly the client myself should have given, selected and given instructions to. Now I understand that the barristers and solicitors have communications. Obviously, that's the whole point. That but this was a very substantive issue where the concern was raised by the solicitor or the barrister, between them. So they had conspired together to my exclusion, and because that was not something that they discussed with me. All I said to them was that, look, I want to appeal the decision of the final hearing, and also, look, I'm making some serious, I need legal advice of what options I have available to me regarding the judicial fraud that I feel I've been subjected to, because I believe the local authority has privately commissioned out the services of the judge. Initially, when I spoke to the solicitor after making that allegation to the barrister, he was trying to convince me that I may be mistaken or maybe wrong, or like, why would they do that, and asking me to justify my allegations. But then subsequently, in the background of them, both of them have colluded and conspired to state that that's the narrative that they're gonna promote. They both agreed with themselves that I may lack litigation capacity to give them on the basis that I'm making serious allegations. So they've not informed me of this. And remember, I've explained to you that in the middle of June that I was supposed to put a statement in. So the day before, I'm trying to get in touch with the solicitor, and I'd reminded him that we've got to put a statement in the following day. He's given me assurances that don't worry about that, all right. But he wanted to, make me aware. I think at that stage, I think the day before the statement had to be handed in. No. I think I was raising concerns then, and then he was saying I don't have availability to speak today. Can we speak next week? So when I spoke to him next week, I told him, look, did you submit the statement? You didn't even take a statement from me. I contacted you a day before to make myself available so we can get the statement written up to comply to the order for it to be submitted the following day on the Friday. And you told me not to worry about that. Now next week, I'm telling you, did that statement go in? And he gives it, no, the statement didn't go in because because of the concerns I have regarding your litigation capacity. And that was obviously a curveball. I'm like, what you on about? You've been tasked to do. You're a solicitor. You've been ordered by the courts I've been ordered by the courts to submit the statement. You're my solicitor. Submit the statement. So he's then telling me, oh no, and it's at that stage that he's mentioned the litigation capacity issue. So then what's happened is that I said, well, if the barrister has concerns, I need to speak to the barrister because I want to alleviate those concerns. So a further appointment has been made, a conference call has been taken place between me and the barrister. And I remind them that there's the Mental Capacity Act, the aspect of I basically tell them that you're talking rubbish because there's an assumption of capacity, and I said, look, what are you alleging that is the cause of my lacking a litigation capacity? Because I don't have a condition or anything like this. I mean, this is just simply it seemed obvious to me that there was fraud and deception taking place by both the collusion of the solicitor and the barrister. But anyway, they then said, no, look, we're going to proceed on this basis now. And then I obviously told the barrister solicitor not to do this, not to inform the courts. But they said, no, we're still going to inform the courts because we have a duty of care to the courts now. So by the end of June, they had the solicitor and barrister. The solicitor had confirmed the courts against my instructions, against my advice to say, look, go seek advice from your senior solicitors or the directors of the Burke Niazi, because I will be taking issue with this. Because at this stage, I was not sure if he was acting unilaterally or under instructions from the council, the judges, or his own barristers. Because I don't know about this. But my further complaint is that on the 20th of May, there was a hearing listed for the 5th of July. And and then at this stage now, on the 5th of the hearing on the 5th of July got hijacked and could not proceed because of the priority given to the allegations being made by my own solicitor and barrister. So if they had they basically sabotaged the hearing of the 5th of July, because that hearing then was overtaken by the ongoing issues that I had of concern that were not being dealt with, because it just got basically hijacked by the courts and everybody else saying that, okay, well, this is now a priority. However, the priority for the 5th of July should have been to review the injunction orders, to provide me with access to my mother, but all those got like downgraded now. And just as a side note, one of the problems I had was that I believe in the middle of April, after I've spoken to my solicitor, Mr. Barrett, tried to secure his services, my mother ended up in hospital. So when my mother ended up in hospital, I was begging. In April, I was literally begging the solicitor to hurry things up because, my mum's going to potentially die. She's in hospital now in April. And I don't know what's happening with her. I want to quickly see my mother. I want access to see my mother. And I had informed him that because you're not my solicitor right now, I've contacted the council because I'm really worried about my mother. I think she's going to die. So I made those, I expressed the seriousness of needing him to be on board in the middle of April. And still he was taking a very lackadaisical approach. So by the time he did come on board, it was obvious to me that his services had no doubt been privately commissioned, but I couldn't evidence that. By the end of June, it became quite clear to me that he was not acting at all in my best interest, and his services had been, but obviously I can't, that was evidence enough for me to be satisfied. Now in June, on the 5th of July, like I said, I briefly got to speak to the barrister beforehand. There was regarding the issue of getting access to see my mother, and this time the barrister, I should have spent more time preparing for the hearing on the 5th of July. But the 5th of July basically got hijacked by my own solicitors and barristers for their agenda of me lacking capacity. But there was serious ongoing issues that I needed to prepare for the hearing on the 5th of July. So my further complaint regarding the solicitors and the barrister is that not enough preparation had taken place for me to represent, because it's an allegation on their part now that they're alleging that I lack litigation capacity, but that's not been proven yet, and yet there are substantive issues for the 5th of July for me to be made aware of, for the solicitor to...
Just bear with this. I'm making note as we go along. So you've asked, obviously, that you think that the solicitor and barrister should have had some kind of consultation with you before your hearing on the 5th of July. So did you have no consultation with them before then in regards to prepping for the hearing? You didn't have anything?
Sorry, say that again.
So your complaint there was that you have a hearing on the 5th of July, and that you didn't have any preparation time with the solicitor or the barrister to, what you were going to discuss.
Yes.
Because they put in the litigation capacity, or did they actually meet? Did you say the barrister did meet with you?
Yes, I mean they briefly met with me before the hearing, saying that they had to prepare something. So it was basically they had not consulted me, but they had prepared like a letter, he needs to be allowed to see his mother. Do you agree with this letter? But like I said, that was not in a consultation. That is something that they knew that they had to prepare something. They did not have a consultation with me regarding giving me a full opportunity to address all the outstanding issues. They themselves had thought that, well, obviously once to see his mother, we'll put this. They rushedly prepared a document, I think a day beforehand, and asked me to agree to it.
So it was the day before the hearing on the 5th of July?
I think so, a couple of days beforehand, that they rushedly prepared a document that they would because obviously they were still representing me, so from their perspective, they knew that they had to do something other than basically say we're not doing anything. But on the 5th of July, what got me was that obviously the other parties were saying that you were supposed to submit a statement in June, that we haven't received that statement. So can you see the priority? There was a hearing listed for the 5th of July. There were certain things we needed to do in preparation for that hearing. One of those things that we needed to do in preparation for that hearing was for me to formally submit a statement, which had not gone in place because obviously they raised this issue of litigation capacity. So that issue did not get dealt with on the 5th of July regarding this outstanding statement, because the statement that should have gone in the middle of June was then basically sidelined because of the allegations of me lacking litigation capacity. So they hadn't prepared for that. They basically they said, "Oh, you want to see your mother, so we're just going to put this like letter in," and it was not through my like addressing all the points. Because obviously there were injunction orders in place, there were other things in place that I required a conference call at length with, but it was quite rushed through. So does that make the situation clear?
Yeah, yeah. So the firm met with you briefly before the hearing on the 5th of July, and they didn't really prepare for the hearing.
Yes, that's right. Yes, because they understood that the priority of the litigation capacity was like their pretext to say that that's why they hadn't submitted the statements. That's why basically they had. This is one of the reasons that they hadn't done any work in my interest before the 5th of July, because obviously they were saying that I lack litigation capacity to instruct them.
Yeah.
Okay, so now
I'm with you. I've taken note of that.
yeah. So now that the 5th of July has happened, and obviously the judges agreed with them that there should be a capacity assessment carried out, and as I mentioned here last time, there's no mention of which doctor should take the place and so on and so forth. But I think the relationship between me and the solicitor broke down at the 20th of July. Because obviously after the hearing, I was asking some serious questions, because the hearing on the 5th of July was evidently a very artificially contrived setup, because I believe it was, everybody knew what was going on and they were all acting malevolently, because like I said, I was asking simple questions like, okay, on the 5th of July, there was not, you've put forward that I lack litigation capacity. The judges agreed with you. He's ordered that at the hearing for there to be a capacity assessment carried out. Can you explain to me why, in an order that we received, that there's already a doctor's name on there? All right, so I was asking some very serious questions towards the end of July. And at that stage, the solicitor was basically explaining to me that because the judges agreed with him, and he's really not in a position to take any further instructions from me, and so the priority now is to get this capacity assessment carried out. But unbeknown to him or me at the time, on the 20th of July, that the local authority and the clinical commissioning group have submitted a separate application for a vaccine application. Okay, so when he's telling me that I can't, basically he's telling me by the end of July, towards the end of July, that I can't take instructions from you because because of my allegation, my belief and understanding and allegation that you lack litigation capacity. He was not able to assist me at all in the CCG clinical commissioning group application for vaccination, which had been authorized in conjunction with the council. So throughout August, I was obviously panicking and wanting to speak to him consistently, and that's what I mentioned to you last time, that one of the further complaints I have is that I left numerous voice messages, I left emails, which is all evidence, and he would not reply back to me. And and briefly he would tell me that there's no further developments. So he's not willing to engage with me because there's no further developments on the case, other than the capacity issue. And yet there were further developments, and I had to point it out to him that there are further developments, because there's been a CCG application in the background. Why are you saying there's no developments? Can we discuss the CCG application? And he says, I was not made aware of this, and he was acting like, oh, I'm an idiot, I don't know what I'm doing, but obviously they knew what they were doing, all of them, but they were just like, oh, I was not made aware of this. What do you mean you were not made aware of this? Then he's saying I was on holiday, or just giving me excuses. But the further complaint I have is that a new application had been submitted in July, and and at the hearing on the 5th of July, obviously the capacity assessment orders were given that it should be taken by such and such a date, and the next hearing was lifted on the I think the 1st of October. So the 1st of October hearing was all to do with my capacity assessment, because that had got delayed from the 5th of July. So that was now a priority. Yet in the background, they had sneaked in a CCG application, and there were attempts to another hearing for that particular application to be heard by a different judge. Then that got declined. And then that eventually, because the judge, that all got they were supposed to be heard at the end of September, the judge refused to hear that case. And so then that automatically got bolted on to the hearing on the 1st of November as well. But my further complaint is that with regards to the CCG application of July, the solicitors who were legally representing me had absolutely no input, had advised me nothing.
So they didn't respond when you asked for advice, and then they've not. So you've gone to them for advice on this CCG application, and they've just not responded to you at all.
Yeah, they're not provided me with anything. But obviously, as you can appreciate, my priority was to deal with the mental capacity issue, and there were other concurrent issues going on as well. You see, so in regards to the CCG application, on the first of October, I found myself in a situation where I had received absolutely no advice. In fact, I was giving them legal advice, but the solicitor explaining to them that there were, this is a very specific issue. The court protect. There were other case laws that I was mentioning to them that this should not be basically railroaded through. And effectively, that's what happened on the 1st of October. That the day that the hearing was listed to deal with other issues, but then it was dealing with the CCG application. And then because I had no legal representation, I had to effectively had nobody legally looking out for my interests, even though I was legally represented. I then had to make my own applications to the judge ad hocly. But mainly and that's quite clearly evidentiable, isn't it? There was a CCG application. I'm claiming that they provided me with no legal advice or preparation.
Yeah, we can definitely take that complaint forward. If you ask them for advice and they're not providing you any advice, they need to explain why, don't they?
Yeah.
So we can take that. We can put that forward, absolutely.
Yeah. So that's evidential, isn't it? They can. I can't be making that up. They can say, well, no, actually, he never asked for the advice. Well, even if let's just say, for example, even if I didn't ask for the advice, they're still under a duty of care to me because an application's been submitted. And they're aware of that application. So they know the fact that there's going to be a hearing. There was as I explained, the hearing on the 1st of October was later decided that was going to be like for the CCG as well. It was all kind of like mangled together. But there was supposed to be a hearing before that. All right, because they was trying to arrange a judge to hear that CCG application. Yet, even then, the solicitors had not chose to prepare me for this. They provided me with absolutely no advice or no preparation for the CCG application at all, and that's obviously an omission on their part because obviously they were aware that there was a CCG application. They should be able to audit or evidence that no, actually we did have a consultation on this date and we did discuss the CCG application, and this is what we advised them because this was a CCG application being made. And one of the questions that I wanted to ask is this, that the CCG application needs to be made independently from the ongoing proceedings. How have they been in a position to hijack these proceedings? Oh, and another thing is that soon as the CCG had made the application to the courts, and at the start of August, the judge on paper had permitted that application to go ahead. So the CCG made an application to the courts, I think, on the 20th of July, and by the 5th of August, a hearing has taken. The judge has heard their application on paper without my involvement and permitted it to happen. So obviously that is something that I needed advice from the solicitor on, that an application has been made, and yet you're my solicitor. Why were you not in a position to raise an objection? And he was telling me he was on holiday, he was not aware of the application, and yet he had to be aware of the application because the judge had on the 5th of August, I think, or sometime in early August, the judge had granted the application. And so therefore that conversation, if I was concerned regarding the CCG application, then the conversation should have taken place, or they should have taken instructions from me to say, well, we appealed the CCG's application. But it was basically, I just felt the fact that the solicitor was effectively no longer looking to represent my interest at all, and allowed the local authority's agenda to be railroaded because the local authority had effectively instructed the CCG to make that application, and then there was no involvement for the hearing for the order that was allowed that CCG application. So basically, on its own alone, the CCG application would have been a court protection hearing matter on its own. That's a full case, that is. Because other cases, as you can appreciate, the CCG application was regarding a vaccine to vaccinate my mother. The vaccine issue had been a serious issue because we're at the height of the pandemic, and there are other ongoing cases in the high courts, that the CCG have brought in isolation to get the people vaccinated. In our particular circumstances, this was an add-on to a very complex ongoing court protection matter. And the manner in which the CC had brought their application was an issue of concern to me. The way in which the judge had basically rubber stamped their application was an issue of concern to me. And it just seems to be that this very serious issue of vaccinating somebody against their wishes, which was other court cases that I was aware of, that other judgments had taken place. This is a very a complex case in its own right. Yet, under my circumstances, it was just something that was slided under the rug, basically, and therefore, sorry, go on.
Sorry, so just want to clarify, so there's two complaints there, isn't there? So the firm told you that they weren't aware of the application and that your solicitor was on holiday, despite the fact that they're your solicitors and you think that they should be aware.
Mm-hmm.
And the second complaint being that they didn't provide you any advice regarding the vaccination order, despite you asking for their help. So there's two complaints there, isn't there?
Yeah, that's right. Yes, and the second aspect of the complaint is that they had received the order after the hearing. So there was a order at the start of August which they had no involvement in. So if an application is being made by the CCG, they're not aware of it. They're saying they're not aware of it, but they only became aware of it when they had effectively received the order in middle of August. So that's what they're telling me. Oh, we've only become aware of it because we've just got this order now. But where on the application would have been made and you would have been made aware of the application, there was a hearing which there was a order by the judge which you could have objected to. And even now, so once you received the order, once they had received the CCG order, they had proceeded. There was no consultation between me and the barrister specifically addressing the CCG's application. That never took place.
Yeah.
Okay. So even at the hearing on the 1st of October, I at no point had any opportunity to get the advice regarding the CCG's application. Never got none of that. So that's that's an aspect of complaint.
And that was on the hearing on the 1st of October.
Sorry, there was no hearing. It was done administratively.
Oh yes. Okay, so they hadn't consulted with you at all before the 1st of October.
Yes, they were not aware of the application. That's what they told me. We're not aware of the application. And then all of a sudden, a hearing has been taken, not a hearing, an order has been made administratively on the papers, which my solicitor had no involvement in, or I was not given an opportunity to object or raise an objection to their application, and it had just been agreed. And then the order had been issued out, a couple of weeks later, towards the middle of August. And at that stage, the solicitor became aware and made me aware that there was an order regarding the CCG application. At which point, I saw legal advice, or someone asking the questions like, why were you not made? Why did you not tell me that there was an application being made? Why did we not put in an objection for the administratively on paper regarding their application? Or why was this application has been allowed? But for me personally, the issue now obviously was the priority of dealing with the addressing, basically just getting some representation or advice or contact. Because in August, the solicitor refused to contact me on the telephone. Okay, and I sent him numerous emails, and one of the emails that he responded to, there's no further development on the case. And I said, well, that can't be the case, and we need to speak about the CCG issue. So that was in August.
Okay.
So in September, obviously, the 5th of July order regarding my capacity assessment stated that it needed to be the capacity assessment needed to be completed, and the other parties needed to be given the outcome, the report, by I think the 3rd of September. Or sometime, but no capacity assessment had been carried out by this stage. So then it was quickly rushed through at the start of September, where the capacity assessment was carried out in my absence based on video recordings and emails that I'd sent. And so one of the issues that I had was that I had sent emails making allegations at the start of September to the solicitor. All right, and after the event of the date or when the capacity assessment should have been handed, the solicitor proceeded to send that particular email to the assessor. That email at the start of September should not have been. Basically, the solicitor had sent information to the assessor that supported the outcome that I lack litigation capacity. So basically, he had cherry picked emails or events or videos that would have basically assisted the assessor to conclude. The only conclusion was that I lack litigation capacity. The assessor had not met me or spoken to me at all, but he had only gone on the instructions of the solicitor. So the solicitor, and then one of the issues I had was that why have you sent an email that I had sent, I think, on the 5th of September, knowing the fact that the assessment should have been completed by the 3rd of September. So already it's out of time. Furthermore, why this email that you've sent to him obviously is when I'm making allegations, and they're not relevant to like carrying out the capacity assessment. So the other complaint I have is that the assessor, the information given to the assessor was simply cherry picked for an outcome that they required. Basically, it seemed to me that they have told the assessor, look, we need you to conclude this, and here's the evidence to support that conclusion, because it was in their interest for me to. It was not basically it was not impartial assessment, and it was definitely not impartial because I didn't even get to speak to the assessor.
Yeah, and in regards to that, this is saying it's going to be a little bit harder because we can't deal with any of the complaints regarding capacity. We can look at, did they inform you? Did they communicate with you? We could potentially look at the complaint that, you know, the deadline was on the 3rd of September, but the firm have shared emails from the 5th of September.
Yes.
We can look at that, but what we couldn't look at is anything, you know, criticising what evidence we sent or anything like that.
No, I understand. You know, obviously you can't challenge the litigation capacity report. I understand that, and I'm not asking for yourselves to do that. But obviously, if it's an aspect of I'm trying to establish malevolence. Malevolence is acting not in the best interest of the client, or they're doing something abuse of power or process. That is something that you can look into. That if the solicitors have received orders, one of the complaints I have. All right, let's get this complaint down. One of the complaints I have is that orders have been written by the court, by the High Court, giving me instructions or acquiring my response. Those orders, one of the complaints I have is that the solicitors have not complied with court orders. So therefore, you can see that is a very serious matter. If the court, on the one hand, the solicitors are saying we are legally obligated to, our obligations to the court is overriding anything you say or instruct us. Hence why they're saying that we need to inform the courts that you lack litigation capacity. That's an overriding objective to us. Yet, the other overriding objective, I would think, is that if the court has ordered something, so if the court has ordered me to supply a statement by a specific date, if I don't respond to that order, that is effectively contempt of court on my part, because a response.
And I have noted that as a complaint where you said that, you know, the court told you to submit the statement before the 14th of June, and the solicitors didn't do this. You're right. That's a service to you, and that's a complaint. Yeah.
Okay, and so in addition to that category of complaint, because that's a category of, so I'm saying what my category of the complaint is, generally speaking, that the orders were given, they didn't follow those orders. That's one example. A further example I'm going to explain to you is that on the 5th of July, the court has ordered that assessments need to be carried out by a specific date, and all the other parties need to be made aware of that. So that's a further second complaint in the category of complaints that the solicitors are not complying with court orders.
So sorry, just explain that again. The court has told them that a capacity assessment has to be taken out by the 3rd of September.
Completed
and the firm.
Yes.
Completed by the 3rd of September, and the firm didn't comply with it.
Yeah. There were orders given on the 5th of July regarding because remember on the 5th of July they're saying that lack litigation capacity. So the judge said, okay, well, fair enough, I agree with you, or I agree that this should be looked into before other aspects. So the court has ordered them to do certain things by particular dates, and one of those is to get the assessment completed. The capacity assessment completed by a specific day at the start of September. So that should have been all wrapped up. So an assessment should have been carried out. The report should have been written up by the by the start of September. I can't remember the exact dates. But by this stage, the assessment has not even taken place. And one of the complaints, so my general second complaint in this category, that on the 5th, you can compare and contrast. Look, there's orders on the 5th of July that you need to do something by a specific date. The other parties in the proceedings, particularly the official solicitor, is saying to the courts or the parties that why have we still not received this capacity assessment in August? Because they were supposed to be completed, I believe. The assessment should have been completed and finalised and submitted to the other parties by the 3rd of September or some date at the start of September.
Yeah.
But it had not taken place. So my second complaint in this category is that on the 5th of July orders were once again not being complied with, and because the capacity assessment should have occurred, and I was asking questions regarding how did you select this assessor? All right, who selected him, and what information have you provided with him? So it was all very haphazardly done. But then obviously I became aware that the assessment had been carried out, and to my conclusion. So when I spoke to the solicitor regarding the capacity assessment, so this is a further aspect of a complaint, is that I said, look, I would like to have a conference call between you and the capacity assessor to ask questions. And at that stage, as a service delivery, there's no consultation. That normally, if I'm speaking to another party, another expert, basically, if I'm speaking to my solicitor and he gets a barrister, then a conference call needs to take place between the solicitor and the barrister, just so he can understand what's being conversed with us. All right, that has happened in the past. Similarly, I would expect I said I want to speak to the expert. So after the expert has concluded that I lack litigation capacity based on evidence on documents that the solicitor has submitted, obviously I took issue with this. I said I object to this. I want to speak to the expert myself. So what the solicitor has done then, said you can speak to him directly. So he's not arranged a conference call. So that's another aspect of a complaint, that ideally, if I wanted to speak to an expert that he's arranged and he's putting forward, then a conference call should have taken between 3 parties. So I could have asked him the questions. I could have asked, the solicitor the questions. So because that would have assisted me to gain clarity of understanding. But he said, no, you can speak to him directly. So when I've attempted to speak to the capacity the assessor directly, his understanding is that he's now going to carry out a capacity assessment retrospectively. So I've asked the solicitor, saying, look, I'm not agreeing with this outcome of this capacity assessment report. I want to speak to the capacity assessor myself. The solicitor has said, okay, well, you go speak to him then. And then the solicitor has told the capacity assessor that Mr. Hussain, you should speak to Mr. Hussain in order to carry out the capacity assessment retrospectively now. So when I've spoken to the capacity assessor in isolation, I asked him the question, is it your understanding that you're going to be carrying out a further capacity assessment today? And he gives it yes. And if that's not the case, I'm not here to partake in a capacity assessment. The reason I'm ringing you up is because I want to answer my questions. And so when I started asking him questions, both directly, orally on the telephone, and then subsequently, his answers were, don't ask me those questions, go ask the solicitor the questions. So can you understand why it was important for me to have a conference call with the assessor in collaboration with the solicitor, so I could gain a clarity of understanding of what's happened here? But the solicitor...
you've asked the firm if you can speak with the capacity assessor to potentially challenge or discuss what he's found. They've told you that's fine, and then when you've spoken to the capacity assessor, he was under the impression that this was a further assessment.
Yes.
And not just a conversation to discuss his findings.
Yes.
Okay.
So that's obviously a complaint on my part, because obviously, I'm calling it, the solicitor's giving me one impression that I'm calling him up to gain clarity on his findings, but yet told the capacity assessor, you've not spoken to him before, speak to him now, and therefore you can add that to your report. Okay.
Yeah, well, I've notified that complaint. So if they're telling you that your meeting with him was just to discuss his findings,
yes,
and then he tells you, well, actually, it's a further assessment,
yes,
then they've not communicated to you the true meaning of the meeting of this. So yeah, that's absolutely a service complaint. I've noted that down.
Yeah, okay, all right. So just moving on from that. So obviously, it's imperative for not only them, the local authority. It's in the local authority's interest to have me assess the lacking litigation capacity. Now, the other complaint I have in parallel to these proceedings, this was a case relating to my mother. Okay. There are other ongoing court protection proceedings that are nothing to do with my mother, but to do with my brother. All right, that the solicitor should have no involvement in, it should not be aware of, because the solicitor should not know anything about this parallel case running by the local authority in a different by a different judge in parallel. However, some of the information that was given to me earlier on, it seems that the solicitor knew about this other case. All right. So when I challenged him upon this, I give it, how could you know about this case? He told me that I must have told him. And I was very clear not to tell him about this other case regarding my brother. All right. So there was further evidence that the solicitor was effectively working on taking instructions from the local authority against my in the background. So there was when I challenged him upon the fact that yes, there are other court proceedings in place, but why do you know about them, and how do you know about them? Because I think his understanding was at the early stages that I would look to seek his representation in those proceedings, but I had never done so. So the point that I'm trying to make is that the capacity assessment, or me lacking litigation capacity, was not only relevant in these proceedings, but would play a pivotal role in other court proceedings that were running in parallel regarding my brother. So obviously, it was very, very important for me to be basically concluded with through the courts that I lack litigation capacity, not only to cover up the failures of the solicitors and the judicial services and the authorities in these proceedings relating to my mother, but they will also become very, very relevant in the concurrent proceedings regarding my brother. So that's why I believe that the solicitor was going above and beyond to ensure that I lack litigation capacity, therefore trying to trick me into carrying out a capacity assessment, because I made it quite clear from earlier on, I will not be participating. You can't force me to participate in a capacity assessment. So anyway, now moving on to October, the hearing took place. Obviously I was not I had to defend both the committal proceedings, the injunction orders and everything else, but obviously there was railroaded through that my mother's going to be vaccinated. So subsequently, after the hearing, I made it quite clear to the solicitors that I do not want you to represent me anymore, and I'm withdrawing my services. Is at that stage that they said you can't do that, because we're now contacting the official solicitor and the official solicitor has agreed that they're going to be instructing us. So obviously the relationship became very, I said I'm not going to be, so they were continuing to represent me when I was not looking to engage with them or looking to engage with the official solicitor. However, I made the solicitors aware that I will be appealing myself the decision of the CCG application to vaccinate my mother. So I initiated those processes. I asked the solicitor to now provide me with the correspondent email address of all the other parties, particularly the official solicitor for my mother. That solicitor, because that was another party, and the solicitor said to me, my solicitor said to me, no, I won't be providing you with that, because that may violate I'm acting in your best interest, because you may actually violate the injunction orders which will restrict your communication with the other parties. So what to do is you provide me with you give me the appeal application, and I will then submit it to the official solicitor. All right. So basically, the solicitor who had already manipulated me into effectively carrying out a mental capacity assessment was asking me now to effectively give him my appeal application, so he could then give it to the official solicitor, whom he can then take instructions from. I said no, I won't be doing that, and so he was basically trying to blackmail me into communicating with the official solicitor. All right. So that's a further complaint I have, is that now that he had the official solicitor's involvement, achieved his objective to get the official solicitor to give him instructions, he was then trying to coerce me into liaising with the official solicitor in order for my appeal application. So I had made it quite clear to the solicitor following the hearing in October that I'm going to appeal this decision, or that my mother doesn't need to be vaccinated, and I've freed there's fraud and corruption taking place. But then he saw that as an opportunity in order to like basically blackmail me, because obviously I was concerned about my mother being vaccinated and dying from this, and so therefore he was trying to coerce me into liaising with the official solicitor and going the channel that he had created for himself, where he would actually not have any accountability to me as the client, but was now effectively the client of the official solicitor. I was trying to coerce me into dealing with the official solicitor, when I made it quite clear I don't want any involvement of you or the official solicitor. This is all like fraudulent. I'm going to deal things myself unilaterally. So that's a further complaint I have, that he was trying to coerce me. Yep, it's all right. So then obviously.
Sorry, so you told the firm that you're going to represent yourself moving forward. You've asked them to share details of your mother's solicitors, the local authority details, so you could manage your own case, and then the firm have refused to share that information unless you work with them.
Just one correction there. It was not the same case. It was an appeal case. So the case.
An appeal case.
Yeah. Regarding the appeal. All right, I did not. They were saying that we're going to continue to represent you regarding the ongoing court of protection proceedings, because they had already got the official solicitor involved in those proceedings. I was now going to instigate unilaterally appeal proceedings, which are separate proceedings, aren't they? They're separate because they go to the appeal court. So I was then I was going to represent myself or make the appeal application myself. This is a separate application, a separate court. It's to the appeal court, not to the court of protection. He was trying to coerce me into basically for his involvement now. So the official solicitor would make my appeal application to the appeal court.
Yeah, and obviously you asked to manage that, and they've said no. Yeah.
Yeah. So
I've noted that.
Yeah. Okay. So what's happened is that I've then instigated those appeal proceedings in unilaterally myself without their involvement. In the background, they are still effectively representing me in the court of protection proceedings. All right. So throughout December, because obviously if they're saying that they're still representing me, I still want to gain clarity of communication. I've told you in November, I've said that I made a disclosure so I get full understanding of their involvement, and so. In December 2022, 2021, I'm ringing them up constantly, leaving them voice messages. I'm having to speak. Obviously, now I've instigated a complaint procedure. Speaking to the complaints manager, speaking to the data protection officer. Throughout December, the firm is simply shutting down. They don't want to speak to me at all now. All right. So in addition to, you're now representing me in the court of protection proceedings. There are ongoing complaints that I'm raising. So you need to liaise with me on this. There are subject access requests that I'm making. That's nothing to do with the official solicitor or your representation in the court proceedings. You need to liaise with me on this. So there are further ongoing issues that I want to speak to them about. I want basically just clarity of understanding, because I don't know where we are in December, because obviously I'm not giving you instructions. The instructions have been given by the official solicitor. The official solicitor is not speaking to me. I'm not speaking to the official solicitor. So I need to know what's happening. Now what's happened is that rather than speaking to me, the solicitor has unilaterally the solicitor Burke Niazis has put in a further application in January 2022 to the courts, without my involvement, without my awareness. And that further court order meant the fact that the court were then given, sorry to, I just wanted to say something. On the start of October, when I attended the hearing myself, following the hearing, what should have happened was that transcriptions should have been given to me of the hearing, because that's what was ordered. The reason that I was contacting the solicitors in December or November was because I was saying that the court had ordered transcriptions to be given of that hearing on the 1st of October, and I've not received them because I need the transcriptions in my appeal application. All right, and the solicitor was not forwarding to me the transcriptions. All right, so that's a further aspect. because he was saying, oh, I don't know who's the court had ordered that part of the payments should have been coming from the local authority and part of the payments should be coming from the solicitor. Yet the solicitor they were not providing me with the transcriptions. So now I'm asking for the transcriptions and they're not giving me the transcriptions. All right. But a further thing is that on the 1st of October, normally a direction hearing is made when the next hearing is going to take place. So I should have been made aware in October when the next hearings was going to take place. But that was never mentioned in court. So yet in October, no mention of the next follow-up hearing is going to take place. Yet I'm not aware of this. So in January time, the solicitor has made an order to the court or himself without my involvement, without the official solicitors, and an order has been secured that the official solicitor is not satisfied with the assessment, because obviously I was not involved in it, that a further mental capacity assessment should take place. On the 10th of October, on the 10th of January, a further order was made to further vaccinate my mother, and within days my mother would die. So my further complaint is that having established that the solicitor was going to be now represented through the official solicitor, why was I not even involved in the hearing? Why was I not even involved or made aware of the court hearing that was going to take place in January? So I was not involved in that at all, not being made aware of it. All I was told was there's an order now, here's the order. All right, so that's a further complaint, that at least that should have been a consultation that should have been taking place, or I should have been made aware of it. Basically, my final complaint is that in January 2022, the solicitor has unilaterally made a further application to the courts, and a hearing has taken place in my absence and awareness, and that is obviously an aspect of complaint. And I think we're now coming to the end of the complaints. So does that make sense?
Yes. So just to double check on that January complaint that you've just mentioned there, Mr. Stone, what application did they put in? Sorry, was this hearing to discuss the second vaccination?
Yes. So what's happened is that, as I explained, there was a hearing on the start of October. What should have happened is a further date should have been allocated when the next hearing was going to take place. That date was never put forward. All right, there was no date. All right, the judge basically, when I challenged him and I told the judge, you're committing fraud, and I believe that this is all fraudulent, he ran away from the courtroom. So he did not give further directions regarding when a further hearing should take place. So then now all the parties were in a state of limbo because they didn't know when the next hearing was going to take place. Somebody needed to make an application. So therefore the solicitor he told me he made the application to the courts in January. So I'm thinking, well, wait a minute, all of December I'm trying to speak to you, talk to you, trying to gain some clarity of all the complexity that's happening, because remember there were like penal committal proceedings as well, ongoing committal proceedings taking place. He was telling me that if he was basically another issue of complaint, he was basically encouraging me to conclude that I lack litigation capacity, because he was saying that if you lack litigation capacity, you can't go to jail then. So he was advising me, effectively giving me advice, stating that, it was potentially in my interest to state that I lack litigation capacity, because that would avoid the committal proceedings. Because there were still, mind you, there were still committal proceedings ongoing. All right. There were still like injunction orders in place. There were still loads of other things in place, and yet the solicitor at the start of January 2022 has put in an application on behalf of the official solicitor, who's now acting on my behalf. And there's also a conflict of interest, because at the start of January 2022, the official solicitor is officially acting on my behalf. All right. Because I potentially lack litigation capacity, and the official solicitor is already acting on behalf of my mother. All right, that seems like clearly a conflict of interest, because effectively there's two civilians here, my mum and me. Everybody else is a professional, and yet the two parties basically in dispute are the official solicitor is representing both of us. All right, and so there's a whole host of complexity, that are ongoing malevolence that's taking place, and fraud and deception. So there's an explosion of loads of issues that I need clarity of understanding on. And at this stage, the solicitor at the start of January saying to me that, well, I don't need to give you any clarity of understanding because, I don't take instructions from you anymore. And we're now going to railroad through the capacity assessment. So the order of January 2022, which my solicitor had sought, was for the judge had ordered that further capacity assessment should be carried out and giving me one further opportunity to partake in the capacity assessment. All right, because obviously if I don't partake in the capacity assessment, it doesn't happen, you see. So they were trying to everybody was trying to bully and intimidate me and force me into taking out a capacity assessment. They were basically effectively blackmailing me to do so because they were holding my mother hostage because I couldn't see her. And like I said, everything was going well for everybody at the start of January at this application. But the application at the same time ordered that my mother should be given the booster vaccination. So on the 10th of January 2022, the court had ordered that my mother should be given a booster vaccination. So I think that was on a Monday. I think it was Monday the 10th of January. By Thursday, they had given the injection. By Friday, my mother was in hospital. By Sunday, the hospital had concluded that she's okay to be returned back home. So she was returned back home on Sunday, I think, or Monday. By the following week, the carer said, we can't take care of her. She's obviously really in a bad state. So she had gone into hospital following being given the second dose of the vaccine. And once they had given the vaccine to her, within days she's ended up in hospital. The hospital have discharged her, saying no, she's okay now. And then the carers said no, she's not okay. They've taken her back into hospital, and then then she stayed in hospital until she died of. They're saying that she died of the COVID. How could she die of the COVID when she's recently been given the vaccine in November and the booster in January? So obviously I've made allegations to everybody that that you basically deliberately murdered my mother. And then so we've gone from, so just to summarize from regarding the solicitor's perspective. So in May I've made the allegation that the justices, Justice Cohen, Justice Cobb, have had their private services privately commissioned by the local authority. All right, I made those allegations. That has led to the solicitors saying that I lack litigation capacity because obviously those are just serious allegations. So going from an allegation that the local authority have been buying off the judges, we've now ended up into a situation where my mother's ended up dead. All right, and this is all because we've gone from a serious allegation to a fatal allegation now. And it's now been a year on. It's coming, obviously, as you know, this is January 2023 now. You would think that there would be an inquest. The local authority are refusing to carry out an inquest because if an inquest was to be carried out, all these findings could be highlighted that this was a situation where the local authority had deliberately forced me out of the care of my mother's life, forced care and custody, taken into forced care and custody in her own home, violated her liberties, and then proceeded to abuse and molest her in their care and custody. Eventually forced a CCG application under the carpet to get her vaccinated. The vaccination has a direct correlation to her dying, and then subsequently at January everything ended because the case had ended. And the reason that the case had ended is because my mum was dead. So that now that my mum is dead, I'm now obviously speaking to the Burke Niazi, saying that obviously I want an outcome of the complaint because I had raised a complaint in November. The Burke Niazi had finalized the complaint in February, and then so obviously the complaint that you have before you is by Burke Niazi's stating that they have concluded the complaint procedure and giving me like 6 months to bring the matter to yourself as the Ombudsman. When I proceeded to bring the matter to yourself as the Ombudsman, you initially rejected the application, saying that it's because it was done by the Court of Protection and I lack litigation capacity. But that was never finalized, and the solicitors that I had were initially brought on by myself, and hence why the case has now ended up with yourself. So I think that I'm satisfied that I've gone through everything now.
Yeah, of course. And like I said, I've taken note of your complaints. So what I'll do now, Mr. Sain, is I will send you something in writing to confirm your complaints that we've just gone through. I can run through them now. I just want to double check. There was a couple of points we picked up previously. I just want to check if you wanted to include them in your complaint. So one of the points we picked up was that the firm didn't make the legal aid application. until May, which was 6 weeks after you instructed the firm. Is that something that you want him to include in the complaint?
I think that's the central point. That is a number one. I've spent some time on this because, as you can appreciate, we had communications on the 1st of April. We had a lengthy conversation on the 9th of April. All right, and because they failed to take legal representation or pull the finger out and represent me or take legal aid, by the 14th or by the middle of April, my mom ended up in hospital, and I was in desperation trying to get them to pull the finger out. And then obviously, as a result of them not representing me in the middle of April, I've effectively violated what they're saying. I've violated the injunction orders by making a video of the house that I had made. I submitted to the courts before leaving, and then, like I said, towards the end of April, I was given assurances that this was going to happen straight away. And the only reason that the finger was pulled out is because, unbeknown to the solicitors at the time, there was a hearing taking place on the 12th of May. All right, and so on the 11th of May, I said, look, I'm attending hearing, and so he could do it. He could have done it within a day. So the day before, he put it on the 11th. He made the application on the 11th of May, when ideally it should have been done on the 11th of August. Because if it had been done on the 11th of August, he had me for my financial statements. I had given him financial statements. But because he had delayed it so much, he said, no, I need an updated version of financial statements. So I had to give him a further set of financial statements. That clearly evidences that there was a delay. And that delay, that is with respect, that delay, in my opinion, is the pivotal point of this whole issue with Burke Niazi's. The reason that there was a delay, in my opinion, obviously you can't investigate this, but I have a belief and an understanding, is that delay of 6 weeks was ample opportunity for the local authority to have commissioned the services of Burke Niazi. All right, hence all the other ongoing irregularities. So the reason that the Burke Niazi solicitors have only come on board and chosen to represent me is no doubt as a consequence of the local authority having Burke Niazi communicated with the local authority, and in the background they've come to some sort of back channel communication and an agreement. Hence why when I attended the court on the 12th of May, it was the official solicitor who was aware of the Burke Niazi solicitors as my representatives, when nobody should have been made aware. So I believe, and like I said, that's not something that you're going to investigate, but it's my understanding that the situation with Burke Niazi from day one was that they had and hence why I told you in the very first conversation that we had that I chose not to be legally represented, because I know the fact that numerous solicitors that I had previously selected in the north were privately commissioned by the local authority. So that's something I've personal experience of, something that you're not going to be looking into. But initially I did not approach solicitors, I approached a barrister. The barrister had then forwarded the details to Burke Niazi solicitors, and I was confident to proceed because I was quite curious to understand how Bradford Council would be able to privately commission the services of Burke Niazi solicitors who are in London. But yet what has proven to be the case in my own personal experience, that's what's happened. So yes, to answer your question, I think that is the first complaint, the priority to understand why there would be what can justify the 6 weeks delay. Now obviously they're not going to say, well, the reason that we were delayed for 6 weeks is we were negotiating with Bradford Council what we could get out of the situation. They're not going to say that, because that's admitting criminality. So what they're going to say is that, it was just work, coronavirus, the work ethics, or work overload, going on holiday. So those are the excuses that they're going to get. But at least you should ask them, why was there a 6 weeks delay? Considering that me and Michael Barrett had a very comprehensive telephone conversation on the 9th, where he had advised me what we're going to do, how he's going to apply for the legal aid, what solicitor, what barrister he is recommending to me, and everything like this. So we had a very comprehensive telephone conversation on the 9th of April. Within days of that conversation, the legal aid application should have been made. So that, yes, to answer your question, I think that's a very important and pivotal point.
Yeah. Well, what we'll do is I'll include that in the list of complaints. And what I'll look to do now, Mr. Stain, is I will send you an email with all your complaints confirmed in writing, so we can, we've got in writing what we've discussed. And then once you confirm back that they're correct, I will then speak to the solicitors, get their comments, listen to what they've got to say, because like I said, we're independent, and then from there I'll look to make my evidence request. But obviously I'll let you know what the solicitors say to me in case you want to make an offer or any answers at this stage. Obviously I'll share everything with you.
All right.
But that's what we'll do moving forward, okay?
Okay, that's fine. Thank you for giving that clarity. But at this stage, you're not looking for evidence. You just basically you got my version of events. You're gonna put that to them. They're gonna comment. You're gonna forward that on to myself, and then if we can come to an agreement without you needing to investigate matters further, that should be what we should be aiming for at the early stages. Is to, like, obviously if they can give me a satisfactory answer and I'm satisfied and I said yeah, that's fine, and then the matter does not need to be investigated. However, if after giving them the opportunity to respond to my grievances, and me not being satisfied, then obviously you would ask for evidence. Then you would start your evidence-based investigation to get a conclusion. Is that correct?
Correct, yeah. So like I said, we'll try and get their version of events, any of their comments at this stage.
Yeah.
I'll let you know what they say.
Okay.
They might just want us to continue with the investigation, and if that's the case, I'll let you know.
Okay.
But then, yeah, the next stage of the investigation will be me to send a letter to you both, requesting what evidence I need to see from you. But I'll let you know and keep in touch with you anyway to tell you what the
Okay, that's fine. And once it comes to the evidence stage, any evidence that they provide, you will be looking to forward that to me as well, yes?
Of course, any evidence that you submit and any evidence that the firm submit to me, what we'll do is I will look at it, I will come to my findings, I'll share those findings with you and the firm. If either of you disagree, I'll send my findings in writing with the evidence that has all been sent in to me. So you have visibility of all the evidence they've submitted, they have visibility of all the evidence you've submitted as well.
Yeah, that's fine. Okay, I'll leave that with you in your capable hands. Thank you very much. And so there's nothing further you need to understand. And it was, like I said, it was not an extensive time period. It was only from April until I believe January when the case ended, and then February, March. So basically just a year period. But evidently there was a lot of issues that were happening in that year period. Yeah. Primarily, my mother's life was going to be coming to an end, and obviously there was many concurrent things going on. And one of the issues I would like taking an objective view upon is that, considering the complexity and all, I've told you, like there was 6-7 separate issues or cases that were ongoing and concurrent. There would have been a lot of input, there should have been a lot of input from the solicitor's firm, and there wasn't, basically. So my overarching complaint, if I can sum it up in a couple of sentences, is that the solicitor's firm there's been an omission of service from the solicitor's firm. There's been an omission of adequate service or appropriate service by the solicitor's firm. So it's not that they did a lot of things that they did wrong. They didn't do anything. And left me in a position of not representing me properly. So that's my overarching grievance, is that they've basically taken a very lackluster approach, prioritized their own agendas, trying to make financial gain for themselves, and basically not given me the adequate service that would be minimum that anybody would expect from a fully funded solicitor's firm.
Yeah, and I understand that, and obviously that's where we'll come in. But like I said, I'll speak to I'll send you a copy of your complaints in writing that we just talked about. Then I'll speak to the firm and we'll go from there. Okay, but if you've got any questions in the meantime, just give me a ring, pop me an email. Okay.
Okay, so can I just ask, just for your time scales, what kind of time scales are we talking about that you would envision having some to your findings?
Yeah, of course. So what I'll look to do at this point, obviously things can happen, but I'll look to try and get to you tonight in writing the complaints. So as soon as you come back to me with confirmation of, yes, these are right, this is exactly what we've discussed, I'll then try and speak to the firm, which ideally will be this week, but that depends on how quick you come back and we agree the complaint. And then following that, I'll make an evidence request. So we normally give everybody around a week to compile the evidence. If it's a really extensive case, we do normally give around 2 weeks. But once that evidence is received into me, depending on the complexity and how much evidence is submitted, obviously that can vary on how quick I get my findings. But I mean, I kind of hope to have this concluded or at least reach my findings by March.
Okay, all right, that's
at the
good.
latest.
Okay, all right.
But again, that's fully really dependent on how much evidence is submitted. If there's hundreds of pages of, as you can imagine, I have to organise it and go through every part of it. And again, we have got a lot of complaints to address. So it might take a little longer, but I'm hoping at the moment that that's the time scale. But again, that can move depending on how quick all parties come back to me.
Okay. Actually, when you've mentioned evidence, there was just one further point. I'm sorry about this. It just come to my head is that
No, not at all.
just the one point is that one of the complaints I have is that normally when I deal with solicitors firms, they put everything in like postal correspondence. So one of the things is that if I'm trying to take on a new solicitors firm, what they normally do is they have like a policy, like they make me aware of all the policies and procedures. I don't know what the terminology is. It's basically like a welcome pack, or they basically tell you.
Yeah.
All right, that should have been done in the post, no? Or I don't. First of all, I don't believe I received that. All right. But I'm not sure. Maybe they sent in an email. But the most overriding thing that I have to say is that they didn't send me anything in the post. Nothing was on a letterhead. And that is
It does depend. They don't have to send it you via the letter or in the post. They can send it to you via email. They don't always have to some solicitors will send you a 30-page welcome pack.
Yeah.
Some solicitors can send you an email to say, as confirmed, we're going to be acting for you. This is how we're going to deal with payments, etc. So I do expect some level of, confirmation they're going to act for you, some level of, welcome, we're going to be solicitors. So I would expect a level of that, but they don't necessarily have to send it in the post. They can send an email.
Okay.
Like some people send 30-page letters, some send one. As long as they're acknowledging that, making you aware that they're going to act for you.
Yeah. All right. I mean, I think the complaint that I have, on what category I'm trying to say is that the only letter, like it's okay to send it via email as a delivery method. All right. So, like for example, you will notice that when the complaint has been handled, a formal letterheaded paper has been on formally letterheaded paper. So when I'm dealing with the complaint, even though that complaint was not equally posted out to me, it was done via email, but it was done through I received a formal letter like with the letterhead. And so therefore that aspect of the complaint that's been given to yourself, you will notice that it's on a letterhead, it's very formal, whereas my representation by the solicitor was always done in a far more informal capacity, where we're exchanging emails, communicating by emails. No formal letter has been given to me. That's the only thing that I was trying to explain, trying to highlight to yourself. Now, for example, it doesn't necessarily have to be in the post. As I explained, the complaint that was handled, there was a certain level of formality. The formality was that I was receiving written correspondence in a letter-headed paper by the complaints manager, who was giving me the terms of reference. I agreed to them. They said that these are the points that we're going to investigate. Everything was done, even though via email, but in a formal letter-headed aspect. Does that make sense?
Yeah.
Whereas when I was
of course.
when I was dealing with the solicitor and engaging his services or communicating, there was nothing written in a formal letter-headed paper. We were just basically just having a chat informally, like in a very informal capacity. I was sending them email, sending them information, and I could do that in an email because obviously I'm the client. But we're talking about like a standard of delivery. Maybe that's not something that you can look into, but it was basically done in a very ad hoc manner. There was nothing in a letterhead. That's what I was trying to explain to you, that other than when I raised a formal complaint with them, and you will see this from the evidence, that they've not sent me anything formally in writing. All right, and that's why once I said, all right, they can send me normally solicitors firms do send you a welcome pack, or something formally in writing, because the case file is it's normally a paper document. So the solicitors like to do things by like letters, because obviously each letter they're charging for, each phone call they're charging for. So ideally, normally what solicitors normally do is that even though they may send a PDF file, a letter via PDF file through emails, they don't usually conduct business operations through email.
Just email, yeah. I mean, I will say, obviously, I've seen a lot of firms and how they communicate, and they all deal in different methods. It really comes down to what we look at is service complaints. So, in what way has that detrimented you, or if you have asked them, please send this to me via post, and then they don't, and they send everything via email, that's a complaint. But we wouldn't necessarily look into
Okay.
Whether they
Okay.
should have sent you a letter as well as an email,
Okay.
or how
Okay.
they've corresponded with you, unless you said to them, "I want you to send me a letter. Don't contact me via email," and then all they do is
No, no,
contact
but
you via email. Then
well, that's
do you
evidently
see what I mean?
That's evidently unreasonable. Obviously, I mean, if I tell them not to do something and they continue to do that, and there's evidence of that,
Yeah,
that's obviously unreasonable. But like with regards to like what I'm trying to say, is, the reason I say this is because if they were to send me something through the post, there would be cost associated with that. Their overriding objective, if I felt always, was that they were just trying to save money. So you can't legally represent somebody, and at the same time, I mean, I mentioned this to you last time, that they were basically telling me that, oh, there's not enough legal aid money and all this, basically complaining to me that they're not getting enough money. And then obviously
yeah,
one of the overriding objectives they were saying to us, oh, you can't speak to the barrister because we're trying to cut down on costs. So at the same time, like you're telling, this is what they're telling me, which I thought was inappropriate, because that's not, I'm not in control of that. So basically, on the one hand, they're saying that, look at poor us, we're not getting enough money. This is a very complex, and yet at the same time, when they wanted to, they made applications to get like capacity assessments, which cost just as a offhand cost £2,000, can cost in excess of £2,000. All right, so it was just basically uh, looking at saving costs, and that's where that's the aspect of service where you can say service, the failure of service is because if they're saying, well, look, we're penny pinching here, we're cutting costs here, that obviously then can have a detrimental effect on the service delivery. There should be a minimum level of requirements, and if they're saying, well, we want to save on postage, we want to do things by email, that's fair enough. But with regards to like sending me through paper documents, when I did say I make a subject access request, as I mentioned to you, I asked for things on paper, they said I have to pay £50 for that. So, and I know that I don't have to pay any money for that. But like I said, we've gone over our time. You've given me more time than I needed. I feel confident that I've articulated all my grievances to a satisfaction for you to encapsulate. But like I said, the grievances, the reason I brought this to your attention is because if they're penny pinching, there has to be a bottom level when that becomes unprofessional or unsustainable as a service. And I believe under these conditions, these circumstances, because of their overriding objective to save money and profiteer and make financial gain, and that's been an overriding complaint of mine, is that they've not only been able to not provide me with an adequate minimum level of service. All right, they've like obviously failed upon that minimal level of service because of malevolence or whatever, but it's all to do with them. They're prioritizing the need to cut costs. So that's the only reason I was bringing that to your attention, because I know as a carer, or as you can appreciate, if you go to hospital and they don't have enough equipment there, because of cutbacks, then you're not able to receive quality of care. So similarly, regarding the quality of service, if they are penny pinching or not even sending me a letter through the post because it's going to cost them too much, then obviously that can have a detrimental effect on the service that they provide. But like I said, I'm grateful that you've given me the opportunity to fully articulate and express myself and highlight those points to you. Hopefully, you'll have an opportunity to fully review what I've said. And like you said, go on.
Listen, I'll get preferably tonight if I can, because I do have another call to take now, Mr. Singh, but I will send a confirmation of the complaints we've discussed. I'll wait for you to come back to me to confirm they are correct again, and then I will try and speak to the firm this week, but I'll keep you up to date, okay?
Okay, and yeah, that's fine. And if I would prefer to speak, if I have issues, I would prefer to have speak to yourself. So if after reading them, if it's just one or two things, I can just say that's mine. But if there's many other issues, would I be able to arrange another call just to clarify?
Of course you can.
Yep. Okay.
Of course, come in to say,
Okay.
yeah, absolutely. I'm always in 9 till 5, so even if you want to try and give me a ring, or if you want to arrange a call, if that's better for you, absolutely, we can do it over the phone. That's not a
Okay.
problem.
Well, thank you very much. It's been good speaking to you. Thank you.
Yeah, thank you very much, Miss Singh. Thank you.
Goodbye.
Bye.
Goodbye.